So this is the fourth and final part of our series of short guides on TUPE and outsourcing. And I thought it might be useful here to deal briefly with some common HR issues that crop up before and during the TUPE process itself. I think from the customer's perspective, the first step is just identify what you want to achieve by changing service providers. You may be bringing in a new provider because they offer a new, more efficient way of dealing with things, because you want a different type of service altogether, or because you do not like the current service provider's employees and the way they perform the services. Alternatively, you may be changing service providers, but it may be imperative to you that one or two very key employees with bags of knowledge and expertise transfer across as well to ensure that those services can continue to be provided in an effective, high quality manner. So ultimately it all comes back to whether TUPE applies and whether you want it to apply. I think customers should also look carefully at their new service provider's staffing plans. Do they fit in with your expectations of how the work will be organised and performed? If employees are going to transfer across, where do they fit into that new structure, and will they be integrated into the new employer's business effectively? These things are really important because they all impact on the day-to-day performance of the services and the quality of those services. So even if, as a customer, you're not directly involved in the TUPE process, I think it pays dividends to keep a close eye on what's going on. If, for example, there are certain key employees you want to go across to the new service provider, are they being given the right messages to encourage them to stay? Are there any specific issues with how the services are currently provided that you want the new service provider to deal with? For example, are there any retraining requirements? For the outgoing service provider, I think there are two main considerations. First, it will be required to provide certain minimum information to the new employer about the employees that are transferring across at least 14 days before the transfer. This is going to increase to 28 days from the 1st of May this year. That information includes information on the employee's identity and age, basic terms and conditions, and details of any grievances, disciplinaries and claims in the last 2 years. The services agreement with the customer may contain more onerous information obligations, so it's worthwhile checking those as well. Secondly, the outgoing employer is also required to inform and consult with employee representatives. If there are no existing trade union reps or other consultative bodies in place, it will be required to hold elections to elect appropriate employee representatives for that purpose. Well, I appreciate that holding elections for employee representatives can be a bit of a headache for employers, and in practice many employers do just decide simply to engage with the employees themselves rather than going through that election process. However, strictly this may be a breach of TUPE, and there can be a heavy price to pay for that, up to 13 weeks pay per employee for failing to inform and consult in accordance with the TUPE regulations. There will be an exception for micro businesses, that is employers with fewer than 10 employees, that will allow them to consult directly with employees, and that will come into force on the 31st of July this year. The way that employers sometimes deal with this is just to write to all of the employees who are affected by the TUPE transfer, giving them information about when and why it's happening, the implications for them, and whether measures are proposed by the new employer. So this is effectively the inform part of the inform and consult process. At the end of that letter, the employer will then often ask employees if they want to put themselves forward as representatives. In many cases, in my experience, employees tend not to, and TUPE is clear that once you've offered employees the opportunity to elect reps and they have not done so, you can then inform and consult with those employees directly. If employees do put themselves forward to act as representatives, provided that they are representative of the whole workforce that is affected by the TUPE transfer, again you may not need to hold any elections. So the consult part of the inform and consult process I think largely depends on what the new service provider wants to do with the employees. If they do not propose any measures, for example, any changes to terms and conditions, then there really is no duty to consult at all. So having sent the letter to the employees informing them that the TUPE transfer is taking place, the outgoing employer's job is done. However, it is important to be careful, as even quite minor changes to terms and conditions, for example, changing the date upon which salary is paid, can amount to a measure for TUPE purposes. I think in practice it makes sense to engage with the TUPE process as early as possible on both parties' sides. The sooner that the new employer gets the employee information from the outgoing employer, the sooner it can assess whether any measures are necessary and inform the outgoing employer of those. And the sooner consultation begins on those proposed measures, the sooner any significant potential issues can be identified and rectified. If the changes and the proposed measures are likely to be significant, it is sometimes worth asking the outgoing employer if you can have access to the employees for the purposes of explaining those changes in more detail. This will enable both parties to deal with any issues head-on and ultimately reduce the risk of liability either from employees resigning and claiming constructive dismissal or from a failure to inform and consult. So I think for the new service provider, the most important thing is to do their due diligence effectively. You'll need to understand at a very early stage what the potential employment liabilities are, as this may obviously have an impact both in terms of negotiations on commercial indemnities and potentially also the price of the services themselves. So you need to look at who the employees are, what jobs they do, what are their current terms and conditions, to work out whether there are any changes you might want to make. Now, sometimes the customer will have a contractual right to request that information early from the current service provider in its existing services agreement, so it's worth bearing that in mind. Equally, I think due diligence should go beyond financial issues, so you'll be looking to understand in particular whether employees have any performance issues, whether any retraining requirements are needed, and for example whether there's any low morale within the existing workforce that you might inherit. Again, sometimes the customer is a good starting point for finding out that information, so it's worth liaising with them as much as possible. So that's the end of our four-part series of short guides on TUPE and outsourcing. I hope you found them useful. If you have any questions at all, then my details are on the page, and they're also on the Taylor Vinters website, which is www.taylorvinters.com. Many thanks.